The Supreme Court has said it clearly. The citizen is not bound by government acts without his consent. Ask yourself, did you knowingly consent? Did you willingly enter their jurisdiction? Or were you tricked by silence, by presumption, or by fear? You were born free. You remain free unless you give that freedom away. Consent is the key. It's how they claim you. It's how you take your freedom back. So withdraw it. Correct the record. Stand outside their jurisdiction because you were never truly inside it to begin with. You see, most Americans believe the IRS is the law. That is, what it publishes is binding. That if a form or a booklet says you are liable, that you are. But that belief is false. IRS publications are not law. They are not statutes. They are not regulations. They are not enacted by Congress or codified in the statutes at large. They are merely administrative guidance, non-binding, non-authoritative summaries. Here's what the law actually says. Only statutes passed by Congress and regulations published in the Federal Register carry the force of law. Anything else, like a pamphlet, FAQ, or an IRS website, is just an opinion. And often those opinions are misleading. The IRS tells you that you're a taxpayer, but it never shows you the specific statute that makes you liable. It tells you that filing is voluntary, but then penalizes you for not volunteering. It treats publication as proof, but in law, only properly enacted legal instruments can bind. Even federal courts agree. IRS publications have no legal effect. They do not create obligations. They do not expand jurisdiction. They cannot override statutes or regulations. So when the IRS says, you must file, ask, where is the statute that says so? When they say, all income is taxable, ask, what regulation implements that claim for private, non-federal citizens? When they say, everyone is liable, demand the statute at large and the implementing regulation that lawfully connects to you. Because if they can't cite it, they don't have it. Guidance is not obligation. Interpretation is not enforcement. A pamphlet is not the Constitution. This is how they keep the illusion alive. They use words of suggestion like should, may, typically, but they act as if those words are law. They count on your ignorance. They rely on your fear. But once you know the difference between law and policy, between enacted authority and administrative bluff, the spell is broken. So read carefully. Ask for the law, not the brochure. Demand the statute, not the suggestion. Because IRS publications are not law. And if that's all they've got nothing at all. Here's a legal fact that changes everything. Most of Title 26, the Internal Revenue Code, has no implementing regulations. And without a valid regulation, a statute cannot be enforced. That's not just a technicality. That's the law. The Administrative Procedures Act requires that if an agency wants to enforce a statute, it must publish implementing regulations in the Federal Register with notice, comment, and legal effect. So ask yourself, if Title 26 is so universally applicable, where are the regulations that make its provisions binding on you? In most cases, they don't exist. Out of hundreds of sections in Title 26, only a small handful have corresponding enforcement regulations. And those that do apply specifically to federal employees, fiduciaries, foreign corporations, withholding agents, or those engaged in federally privileged activities, not to private non-federal Americans living and working in the sovereign several states. Title 26, Section 1, the statute that supposedly imposes the income tax, has no regulation stating who is liable. None. The IRS assumes it applies to everyone, but they cannot point to the law that says so. The courts have ruled that without a regulation, a statute has no legal teeth. It's merely a statement of intent, not a binding obligation. So here's the test. Every time you see a statute, ask, where's the regulation? Where's the force of law? Where's the jurisdictional reach? If it's not published in the Federal Register, if it doesn't go through proper rulemaking, if it doesn't expressly apply to you, then it's not enforceable against you. This is not opinion. This is settled law. Regulations are the bridge between statute and enforcement. No regulation, no bridge. No bridge, no obligation. And when you pull back the curtain, you see the truth. The Internal Revenue Code is filled with sections that look official, but are legally toothless, especially when it comes to free Americans. The government cannot tax you by implication. It must prove its authority, demonstrate jurisdiction, and enforce through lawfully promulgated regulation. And when they don't, you are not obligated. No regulation, no liability. No law, no tax. The Supreme Court has always said the income tax is constitutional only as an excise, not a direct tax on the people, not on wages earned in private employment, not without apportionment, not without consent. So if you're not receiving federal benefits, not holding federal office, not operating in a federal capacity, then you're not the proper subject of the income tax. Congress cannot expand jurisdiction by redefining words. The IRS cannot bypass the Constitution with form letters or threats. And no court can create a liability that the law itself does not impose. The Supreme Court decisions still stand. The income tax must be limited to privilege. That's the boundary. That's the law. So when someone tells you that the Supreme Court said the tax is legal, you simply say yes, but only within its proper jurisdiction. And if that's not you, then you're not liable, not legally, not constitutionally, not lawfully. This is why the Buck Act was passed in 1940, to allow federal law to operate within the states, but only with state cooperation and your silent consent. They expanded jurisdiction by presumption, not by law. But now you know, the federal government's reach ends where the Constitution says it does. And if they want jurisdiction over you, they must show how you entered it voluntarily. Because without that link, without that contract, that benefit, or that federal connection, they have no authority, no jurisdiction, no liability, no tax. Here is a truth they don't teach in school. The federal government has limited jurisdiction by law, by geography, and by consent. The Constitution created a federal government with enumerated and limited powers, not unlimited reach. Its authority is confined to what is expressly granted, and nothing more. So where does Congress have full jurisdiction? Only in 3 places: the District of Columbia, federal territories like Guam or Puerto Rico, or federal enclaves like military bases, federal buildings, and lands ceded by states under Article 1, Section 8, Clause 17 of the Constitution. Everywhere else inside the boundaries of the several states, the federal government operates only by delegated authority and mutual consent. So what does that mean for the income tax? It means Congress can tax in its own house, federal lands, federal people, federal functions. But it cannot impose a direct tax on the private earnings of Americans in the several sovereign states unless that tax is apportioned, which the income tax never is. And here's where the trap is laid. Most Americans assume the Internal Revenue Code applies to them simply because they reside in a state. But the code itself, Title 26, never says this applies universally. It operates within federal jurisdiction over federal persons and within federal territory. If you are not living in Washington, D.C., not working for the federal government, not receiving federal benefits, and not engaged in a federally privileged activity, then you are not within federal jurisdiction. Jurisdiction must be shown. It cannot be presumed, and geography is a limiting factor. If you live and work privately within a state, you are under the authority of your state, not Washington, D.C., unless you contract into their jurisdiction. The phrase citizen of the United States doesn't mean what you think it means. In law, it has a very specific, very limited definition. And unless you choose to accept that status, you are not one. The 14th Amendment created a new class of citizenship. It says, quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States, end quote. That phrase, quote, subject to the jurisdiction thereof, end quote, is the key. It does not apply to everyone just because they were born on American soil. It applies to those who accept and submit to federal authority. Why does that matter? Because a citizen of the United States is a political status tied to federal jurisdiction, not to the land, not to the people, to the federal system. If you are a citizen of the United States as defined in federal law, then you are presumed to be subject to federal legislation, subject to the Internal Revenue Code, subject to federal administrative courts, subject to all the presumptions that come with that status. But if you are a state national, a man or woman born in one of these several states, not engaged in federal employment, not accepting federal benefits, not volunteering into the system, then you are not automatically a U.S. citizen in the 14th Amendment sense. You are an American, not a federal subject. The Supreme Court has confirmed it again and again. There is a distinction between the citizen of a state and a citizen of the United States. And Congress only has jurisdiction over the latter. So here's the bottom line. If you never knowingly consented, if you never voluntarily accepted that status, if you never contracted into that jurisdiction, then you are not bound by it. You were born free. You are governed by your state's laws and by natural law, not by federal statutes meant for those who choose to enter their system. This is why the IRS asks for a Social Security number, why it wants you to declare yourself a U.S. person, because without your consent, they have no lawful authority over you. You are not a citizen of the United States unless you say you are. And if you don't, they have no claim. The income tax is not based on your earnings. It's based on your participation in a federal privilege. That's the secret they hide in plain sight. You are not taxed for what you make. You are taxed for what you accepted. The federal income tax is an excise, a tax on the exercise of privilege granted by the federal government. That means it applies when you're doing something that the federal government has the right to regulate, like holding federal office, operating under federal license, or receiving federal benefits. So here's the truth. If you're not engaged in a federally privileged activity, you are not subject to the federal income tax. Working for a private company in Virginia, that's not a privilege, it's a right. Earning wages from your own labor, that's not income under the tax code. It's an exchange of energy for value. It's your natural liberty, not a federal benefit. But apply for a Social Security number, accept Medicare, register as a taxpayer, file a 1040. Now you've entered their jurisdiction. You've volunteered into their system. You've accepted the privilege, and with it, you accepted the liability. They count on this. They don't prove jurisdiction. They manufacture it through your own uninformed consent. The tax only lawfully attaches when you receive a federal benefit, you operate under a federal privilege, or you act in a federal capacity. That's the nexus. That's the hook. And absent that, there is no lawful imposition. You were never meant to be taxed for living free. You were never meant to be taxed for working privately. You were only meant to be taxed if you entered their domain and accepted the deal. But here's the good news. That deal is voluntary, and consent can be withdrawn. If you stop accepting the federal benefit, if you revoke the elections you made, if you correct the record, then the jurisdiction dissolves. Because without a federal privilege, there is no taxable activity. No privilege, no nexus, no jurisdiction, no tax. What does 26 U.S.C. Section 1 actually say? What if I told you the entire income tax system begins with a sentence that doesn't actually impose liability? That sentence is found in 26 U.S.C. Section 1, and it says, quote, "There is hereby imposed on the taxable income of," end quote. And then it cites various filing statuses. It looks official, right? It sounds official. But read it again, and it says the tax is imposed on taxable income. It does not say who is liable to pay it. It does not define who must file, and it does not identify the jurisdictional reach of that imposition. In law, a tax statute must do more than suggest. It must be clear. It must express who is liable, what is being taxed, and where that authority comes from. Section 1 does none of these. Instead, it assumes that you already know that you're a taxpayer. It assumes that somewhere else the obligation is made clear. But here's the key. It isn't. And that's the beginning of the illusion, a presumption of liability rather than proof of it. Federal law requires clarity when it comes to taxation. You can't be punished unless liability is expressly imposed by statute. So where is it? It's not in 26 U.S.C. Section 1. That much is clear. It lists filing statuses. It references taxable income. But it never says who is made liable. Compare to Section 5005, which governs alcohol tax. It says, quote, "The manufacturer or importer shall be liable for the tax," end quote. This is clear, precise, and there's no doubt. But Section 1, nothing. Even 7701A14, which defines taxpayer, is circular. Taxpayer means any person subject to any internal revenue tax. That's like saying, if you're liable, then you're liable. But if the law never made you liable, then you're not a taxpayer. You're a non-taxpayer and outside federal scope. That's not rebellion. That's the rule of law. Every law requires the legal authority to reach the person or activity being taxed. But Section 1 of the Internal Revenue Code never explains who is within federal jurisdiction, or how that jurisdiction is obtained, or what activities fall under it. That's not an accident. That's how they trick you into volunteering. The Supreme Court has ruled over and over, quote, jurisdiction must be proven, not presumed, end quote. And when it comes to taxes, that means proving you're engaged in a federally privileged activity, proving you're in federal territory, or proving you've consented. If you work for a private employer in a state, don't receive federal benefits, and haven't filed or signed anything claiming to be a U.S. taxpayer, then they have no jurisdiction, not constitutionally, not statutorily, not lawfully. What does 26 U.S.C. Section 1 actually say? What if I told you the entire income tax system begins with a sentence that doesn't actually impose liability? That sentence is found in 26 U.S.C. Section 1, and it says, quote, there is hereby imposed on the taxable income of, end quote, and then it cites various filing statuses. It looks official, right? It sounds official, but read it again, and it says the tax is imposed on taxable income. It does not say who is liable to pay it. It does not define who must file, and it does not identify the jurisdictional reach of that imposition. In law, a tax statute must do more than suggest. It must be clear. It must express who is liable, what is being taxed, and where that authority comes from. Section 1 does none of these. Instead, it assumes that you already know that you're a taxpayer. It assumes that somewhere else the obligation is made clear. But here's the key. It isn't. And that's the beginning of the illusion, a presumption of liability rather than proof of it. Let's go back to 26 U.S.C. Section 1. It doesn't create liability. It doesn't establish jurisdiction. It doesn't cite an implementing regulation. So why does the IRS treat it like it applies to everyone? Because they count on your consent. You signed a W-4. You accepted a Social Security number. You filed a 1040 under penalty of perjury. You call yourself a U.S. citizen or taxpayer. Now they presume jurisdiction. Section 1 only works because the IRS assumes you're already within their system. It doesn't bring you in. You see, you do that by signing, filing, or applying. But here's the truth. Consent is the only bridge between you and their system and their tax code. And if you never gave your consent knowingly, you have every right to withdraw it and correct the record. Without jurisdiction, without liability, without regulation, 26 U.S.C. Section 1 is just ink on white paper.